Yeah, guys, I'm sorry that we had to shorten lunch and shuffle things around, but we've had so many great presentations and we just didn't want to stop people, so here we are. For those of you that were at Superpod last time, so not last year, but last time, you may remember that I bolted out of Superpod fairly quickly. And I wanted to explain to you a little bit about why. But before I go any further with that, I would like to say thank you for getting me here now. Muriel Arnell and her NGO One Voice from France flew me all the way from New Zealand just for Superpod, so thank you, Muriel. Lovely folks have been hosting myself and also Morgan's lawyer Matthew Spiegl, and they have been shuttling us around the island and provided vehicles and all that lovely stuff that makes the San Juan Islands as special as they are, so thanks guys. Right, well without further ado, this is why I left. I got a phone call that there was a young lone orca that had apparently been alone for, by the time I heard about it, 3 to 5 days, separated from other orca. There was one guy who was attempting to make friends with it, and turns out he was harassing the animal, but we didn't know that at the time. And anyway, so there was this lone animal. The government had asked me to please not tell anybody about it because they didn't want a whole lot of tourists turning up. So that's why I had to leave without saying much about it. And off I went. It was a very tragic story and it could have had a much better ending. So spoiler alert, it's not good. But we called him Tiger because he had these remarkable patterns on him. That's not a facet of the light. He really had this pigmentation on him. One of the most beautiful patterns on an orca that I'd ever seen. And he was a remarkable little orca. And if I do what I've now come to call a Charles and start crying in the audience, I'll just walk behind here for a moment and try and see if I can come back out, because Charles had me in tears as well. So I was very, very fortunate, like Charles, to have the opportunity to work with Jeff Foster. Jeff flew all the way from the States with his wife Katie, and they came down with a whole team of the world's experts in rehabilitation of orca. And this was a remarkable opportunity for us to learn as a group, and also to help this little orca. And Jeff and I were able to get very close to him. He was very willing to interact with people because he was so starved for attention. And I had spent, at this stage, by the time Jeff arrived, it was 9 days, interacting with him, getting him habituated and used to being able to touch him. And the reason that we wanted to do that was that for the intervention, we didn't want him to be stressed and startled. So Jeff looked at him, and this is what Jeff ascertained. Everybody can read, so I don't need to read it for you. And we went to the New Zealand government with this information. And sadly, the Department of Conservation became the Department of Conversation. And they talked and they talked and they talked and they talked. And we were having meetings, some of them were 6 hours long. Every single day we had to drive 2 hours to get to the meeting and 2 hours back again. And then we started refusing to go to the meetings and told them they had to come to us. The meetings went on and on and on, and 18 days of meetings that they refused humane intervention for this orca. And one of their excuses was that we do not help individuals. And I looked them in the face and I said, you're going to tell me that you've never rescued an animal ever? And of course there's thousands of animals in New Zealand that they've rescued, including stranded whales. New Zealand has a very high record of rescuing stranded whales and dolphins. So eventually, with some cajoling and, I don't want to use the word threatening, but let's just say cajoling, that we convinced them. And after 18 days, Jeff, was able to slip a very soft rope around the little guy's tail, and within 15 minutes, not only had we caught him up, but we actually had him ashore. And we put him in a freestanding swimming pool so that we could maintain him better, because he had been in an area with huge tides. And they were able to, this is Jim and there, and that's Jeff's hands. And they were able to put a tube into him and start getting electrolytes into him. And then after a couple of days, we was putting blended fish. One of the locals kindly donated their blender. It'll never be the same again, I think. And we were able to feed him, and it was amazing because within an hour of us giving him something to drink, he started peeing. And that peeing was really important because we were able to see that his kidneys were still functioning. Because remember, orca get their drink, their water from their food as well. So he had been at this stage at least 18 days without any food or water. It was disgusting to see what that government was doing, and that's my government, and I was absolutely devastated. Sadly, despite all of the efforts of the team, and I'm talking 24-hour care with at least 4 people helping him at all stages, he passed away. So, because I can't talk about it even now, there's a poster. If you go past the Eco-Joia people who are supporting so many great NGOs, past their t-shirt, buy a t-shirt on the way, past their t-shirt stand, we've put up a poster and described what happened. The thing about this is that he's not the only one. Other governments are making the same mistakes in different ways. The southern residents here, it's politics. In the Netherlands, it's politics. In Spain, where Morgan is now, it's politics. And we just have to start putting our foot down and not dealing with these politicians. We have to find a way to do things better. And we're really, really fortunate for us with the Free Morgan Foundation that we have Matt, because we're going down the legal track now. We're going after the government, and it's making a difference. So I want to tell you a little bit about the updates with Morgan. For those of you that don't know about Morgan, it's an incredibly complex story with all of these governments involved in one level or another. And I would recommend, if you don't know her story, to go to the Free Morgan Foundation website, because then you'll hear a story where someone's not emotionally telling it. And it's true what you're going to hear about the updates. She is now pregnant. I mean, look at the size of her. That is not a modified photo. It is not stretched. She is just epically huge. And the veterinarians and the trainers swore black and blue in court. It was so in court that she was not pregnant, when we believe that she had already been pregnant for a few months at that stage. We won't know for sure until the calf is born when she actually did get pregnant, but we believe that it happened on SeaWorld's watch. Because remember, SeaWorld said, no more breeding. Naomi brought this up. And this is epic. This is a huge step forward. But they didn't keep that. Because as she pointed out, Wolfgang Kiesling, who owns Loro Parque, was determined to get Morgan pregnant. He is an animal hoarder, and he wanted more. He wasn't satisfied with having all the orca that he already had. This was supposed to be the last generation of orca in captivity for SeaWorld. So what they did was they abandoned the animals. And as Naomi said, we're now making this call for people to really speak up about this. Make people aware, because SeaWorld haven't kept their promise. This happened on their watch. Now, I've done a little bit of poking around in the scientific literature, and I found a publication by SeaWorld that tells us that males become sexually mature and are able to father calves at just 10 years of age, which means that the 2 males at Loro Parque were certainly one of them sexually mature, one of them very close, and certainly now both of them are, and either one of them could have impregnated Morgan. Now, excuse me, Keto, this guy, he's the one who killed Alexis Martinez, and it just makes no sense to me that you would breed an animal that has already killed somebody. The other animal, Tekoa, has, he basically killed Claudia, another trainer, but they managed to revive her. They gave her CPR and she came back. So neither one of these males should have been bred with Morgan, just on an ethical standard. And then what the hell are they doing breeding a whale that they are claiming is deaf, that cannot communicate with its calf? I mean, how irresponsible is that? So when is she due? We don't actually know. It's a moving feast, as it were. Loro Pake keeps playing the shell game. You know, that shell game where you put the pea underneath the cups and you move it around? That's what's happening. They keep moving the dates. They keep having different excuses about what's going on. But once the calf is born, then we'll know a little bit more about when she was actually pregnant. So, oh gosh, that's a bit pale up the top there. You can't even read the numbers. But that's supposed to say 338/97, and that's a regulation that Matthew has been working on for the last 5 years, Matthew, something like that. It's been pretty intense. He's going to speak about that, but what I wanted to also mention to you was that because of Matthew's work, we had an amazing opportunity to be able to present his work to the European Parliament. We found out only a couple of weeks before we were due to speak, and we don't have the funds ourselves personally, and the Free Morgan Foundation didn't either. So together with a bunch of people who helped us, including Lee Harrison, who very kindly drew this lovely cartoon for us, we set up a GoFundMe campaign to fly Morgan to Parliament. And our lovely Morgan's Angels, many of you out here in the audience, thank you so very much for helping us get there. We managed to raise the money and headed off to Brussels. And we took Morgan with us. This is a little replica Morgan, and she was very proud to be at the European Parliament, and so were we. So the very simple thing that you should have as a bit of background before Matthew launches into the whole legal side of things is that when you move an animal that's an endangered species, then you have to have permits. Makes sense, right? So if you just think that she's coming from the Netherlands to Spain, she needs a permit. And she needs what's called a transaction-specific permit. So there we go, a certificate. And there's a scientific group that looks at how effective the laws are in terms of dealing with these animals. And they have determined that these sorts of permits allow greater scrutiny of commercial activities involving Annex A species. Now, Annex A is important, and again, Matthew's going to speak about that, but basically it just means wild born, okay? Now, the reason also that these permits are so important is because they deter laundering of wild specimens into the system. Now, that's not us, radical animal activists, that I've now been branded saying this. Okay, this is the scientific group of the European Parliament and European Commission who are saying laundering of wild animals into the system. Now, Morgan was the first wild-born orca in 13 years to come into captivity, worth millions of dollars. Insiders in the industry tell us anywhere from $10 to $20 million. And if she's sitting at around $20 million, she's one of the most valuable animals in the world. There are 10 orca in Europe at the moment. She's the only wild-born one. And when she has the calf, she will still be the only wild-born orca there. So she's the only one that is protected by this particular law. The same scientists say wildlife trafficking has become one of the most profitable criminal activities worldwide. This is from an EU report. Most of us think about wildlife trafficking as people smuggling animals at the border. This is a case, you can see all the turtles full going across a border. We think of it as poaching, but not many of us think of it as guys in business suits and ties selling tickets. But that's exactly what's going on here. Make no mistake, this is laundering, and they're using the law to try and support it. So until we had Matthew come in, we didn't really have a way to fight this. We've now found that there's been 13 species that have been used in the same way as Morgan. 3 of those in the EU, wild caught and put into the system and used commercially, traded and bred by the captivity industry. So Morgan is, although she's a single animal, she's representing a number of other species, and we heard from the Commission when we were in Brussels, thousands of animals that they permit every year, and yet they are saying that there is not a problem. So without further ado, I'm going to hand over to Matthew. I'm not going to take any questions now, but after Matthew we can do some questions. So applaud afterwards, because Matthew's talk is much better than mine. Thank you.
Thank you, Ingrid. And I want to shout out to everyone who supported our GoFundMe campaign to get us to Brussels. It made the difference. So we were actually in Brussels on June 19th, so it was not too long ago. We had the opportunity to go and present our petition to the European Parliament Petitions Committee. And what we were doing is basically had 3 requests. We wanted the petition to stay open, which means that the European Commission would have to keep looking at the issues we were raising. It would be very easy to just say, we didn't see a problem, and close the petition, and we'd be out of luck. So the first request we had in the Parliament was, keep the petition open. We have things that need to be addressed. We wanted the Commission to revise the EC certificate template. We'll get into that a little bit, and that is not only a benefit for what happened with Morgan and her certificate, but all the Annex A wild-born animals traded in the EU are traded using the same template, and it's just a generic form. And that has created a major problem for us to be able to really address Morgan's problems. And the third request we had was to refer the matter to the Court of Justice for the European Union, to ask the Court of Justice to give us a definitive interpretation of EU law, because up till now, it's the European Commission that has been deciding whether the regulation they wrote was done properly, and we're contesting that it wasn't. So we obviously used Orca as an example to expose what was considered a transposition error in the Commission's taking of the basic regulation in the EU, which was implementing CITES, which was the Convention on International Trade of Endangered Species of Wild Fauna and Flora, and implementing that within the EU. And there are a few nuances, but the EU wildlife trade regulations actually are stricter and provide more protections if they're properly applied. So in the EU, in the eyes of the law, not all orca are equal. We have 2 categories under EU law. Annex A, wild-born, and Annex B would be captive-born. So they're afforded different rights and protections. So again, Annex A, wild-born specimens, and under EU law, they're prohibited from being used for primarily commercial purposes, and yet there's Morgan at Lower Park. So the specific regulations, Council Regulation 338/97, it's the basic regulation, and there are 2 articles in that, Article 8.1 and Article 8.3. So Article 8.1 says very specifically that display to the public for commercial purposes, use for commercial gain of specimens of the species listed in Annex A shall be prohibited, period. That's the starting point for the trade of any Annex A specimen. There is an exemption provision, which is Article 8.3, and it allows for exemptions from these prohibitions to be granted permissively. They're not mandatory, and they're issued by a certificate, and it's done on a case-by-case basis. So they're supposed to be very restrictive. Every time an application comes for an Annex A specimen to be used to get an exemption, the management authorities for the individual countries are supposed to really comb through the application, make sure everything is what is being portrayed, and the uses for the exemption are actually accurate as to what is going to happen with Morgan. So the 3 major breakdowns of the exemption categories are 8.3E, which is for advancement of science, and this actually is for medical experimentation, and to get an exemption for this is the highest standard. 8.3F is an exemption for breeding, and it has to be intended for breeding and propagation purposes from which conservation benefits will accrue to the species concerned. And obviously, when you've got captive orca being bred, there's really no species conservation. They're not going back out to the wild. And then there's 8.3G, which is the exemption that Morgan's permit was granted under, and it's intended for research or education aimed at the preservation and conservation of the species. So when you read those words, it seems pretty clear that they're supposed to be using a legitimate research project or serious education use, and not just showing her selling tickets, having her perform for audiences. So over on the right, you see the front page of Morgan's EC certificate, and it literally is a single page, or one piece of paper, two sides printed. The first side is really what we're dealing with, and of that, there's one line in the middle we'll get to in a second, is really the whole issue we're now fighting over with Morgan. And it's basically taking a very restrictive regulation, and through their transposition into the implementing regulation, they have made some major mistakes. So there have been some opinions about how you look at the law and interpret it in the EU. And in 2001, there was an advocate general from the European Court of Justice talking about the same regulation, stating that according to the court's case law, derogations or exemptions from general provisions are to be interpreted restrictively. It goes on, this applies to Article 8.3, which is where the exemption for Morgan's petition comes from, or permit comes from. And it says, again, it has to be strict, closely reviewed, and not broadly interpreted. So the basic regulation, the wording is very clear. The implementing regulation, which the European Commission promulgates, and for people from America, they'd be like, you would have federal laws, and you'd have then the Code of Federal Regulations, which are used to enact those laws. So the implementing regulation is 865/2006, and that contains all the forms used for transfer. It includes the CITES documents or part of this implementing regulation. But because we're in the EU and CITES is about cross-border trade, there's no border within the EU, so they can't use a CITES export or import permit to move Morgan within the EU. So the EU created a specific document for intra-EU trade. Again, this is the single page, and it serves two purposes. It serves as the exemption certificate. So the middle part where the arrow is pointing is where the exemptions are supposed to be identified, and also serves as a transfer permit. And so the transfer permit is under a different section of the regulations. And part of the problem is the Dutch government wanted to say that once Morgan was transferred from the Netherlands to Spain, that the transfer permit was worked. And so it was over and they had no more responsibility. The problem is the exemption certificate is still active and alive. And we've just recently had a ruling in a separate Dutch court case that acknowledges that fact, that it is still valid and still active for the exemptions. So we used Morgan as a case study to Parliament, and we, again, focused on her as a wild-born Norway and Annex A specimen, going from the Netherlands to Spain. Again, you see a larger rendition of the exemption permit. And so the transposition errors, you'll understand the little slashes in a second, but we're arguing that the European Commission, in implementing this regulation, basically commingled / condensed / unintelligibly took these three separate exemptions under three different paragraphs for the science, breeding or propagation, research or education, E, F, and G, and they put them on a single line of text in the form, which is line 18.8. So this is the actual checkbox on the form blown up, and the text again says, are to be used for the advancement of science / breeding or propagation / research or education or other non-detrimental purposes. So three separate exemptions with three very different standards are then condensed onto this single line of this permit, basically just to save space so they can keep the permit to a single page. In 2012, they revised the form. Basically, they changed it from line 18A to now it's line 19D, but they kept the exact same syntax and grammatical errors of just running everything together. So it still exists. So in addition to our petition, we have a separate court case still going in the Netherlands. And in that court case, in April 26, we had a ruling, and the court now is acknowledging that Morgan's certificate was issued on the basis only of Article 8.3G of the regulation for research or education. It was not issued for breeding. So there are consequences of understanding what exemption was actually granted and what uses are permitted or authorized. And the problem with the permit is they're not plainly stated, so they can't be enforced. So you've got these 3 exemptions, not plainly stated, and that leads to confusion by the management authorities, the gatekeepers, the ones who are supposed to be looking out for Morgan's welfare and making sure that the laws are being followed. So both the Dutch and the Spanish management authorities, and these are the CITES management authorities who oversee this whole process, have looked at line 18.8 of the certificate, and they basically said that's the sole document they're relying on, and because that checkbox has everything on one line, their position is breeding Morgan was not prohibited, only because that line has that checkbox and because it's worded the way it is. So the recent district court ruling from the Netherlands actually noted and confirms the argument that we're now making, that the certificate, the wording in conjunction with the basic regulation is actually a contraction of these conditions. F, breeding, propagation, and G, research are just being combined when they're not supposed to be. So we now have the Dutch court sort of backing us up in the argument we're making to the European Parliament. So again, the CITES management authorities, if they don't know what's actually authorized, they can't enforce. They don't know what is supposed to be happening, and therefore you have the ability to make sure that regulations are followed or compromised. And in Spain, that leads to mischief. So as Ingrid said, Morgan is now pregnant, and repercussions of that is Morgan being an Annex A specimen under the law, because she's bred with captive-born males, her progeny will automatically be Annex B. They're not going to be protected like an Annex A specimen. They're not going to have the same restrictions on commercial use. That's where her value comes in as the new bloodline. Any progeny of hers can be traded outside the EU to other parks used commercially. She'll still always be an Annex A specimen, but every calf she gives birth to will be Annex B, can be exploited commercially. So that's why it's so important that we get this right. So again, Ingrid is talking about deterring laundering of wild specimens into the system. And it's something the European Commission says they're trying to support and work on to prevent this from happening, but they're not doing a very good job. The other part is the requirements of the regulations are that if there is an unauthorized use, sanctions are mandatory. If they have bred Morgan without permission, sanctions have to be imposed. There's a whole range of sanctions. It could be anything from a fine, slap on the wrist, to confiscation of Morgan and her calf, to various other issues. But some sanction has to be issued if we establish that the authorization was not there to breed her. So we had our hearing before the Petitions Committee on June 19th, and normally before you're having your presentation, the Petitions Committee puts out what's called a notice to members, where the European Commission basically provides a written response to the arguments we make in our petition. This was issued 10 days after we actually had our hearing. The Commission came in and only presented an oral or discussion of the points, so we had no knowledge going into the final hearing what the Commission's response was going to be. 10 days after our hearing, we got this notice of members from the European Commission stating basically, well, here it is. Let me read it to you. So the Commission has not been made aware of any major problems with the implementation of these provisions during the last 17 years. Also, no relevant issues were raised in the very extensive study on the effectiveness of the EC wildlife trade regulations carried out by the Commission, for the Commission by Traffic. It's a wildlife trade monitoring network that was commissioned by the European Commission in 2007. And when they put that in writing, they also included the hyperlink to this actual report from 2007. I had never seen it before, so I thought I'd better take a look at it. So our petition in paragraph 24, and it was a rather large petition, but it specifically said, we're requesting the Commission amend the design of box 18 of the EC certificate particularly line 18A, to be consistent with the provisions of Articles 8.1 and 8.3 of the regulation. The effectiveness study that the European Commission cited as supporting their position in defeating ours, actually on page 62, and I think what happened, they only read page 61, and they didn't get to this page. Because you can see, it says that the study points out that box 18 on the EC certificate does not correspond directly with the range of exemptions set out in Article 8.3, and that the situation could be clarified through amendment of the design of the certificate, including alignment of box 18 to Article 8.3, which is exactly what our petition is about. So we now had this additional bit of information, and at the hearing we ran into a little bit of a strange situation, probably because Ingrid was there. We got through our presentation, and the petitions committee was supposed to vote, but they didn't have a quorum. And so they couldn't vote on whether to keep our petition open or not. And we couldn't come back the next week because we had to fly quite a distance to get there. So on the 19th, the decision was, under their rules, they had to keep the petition open until the next committee hearing, at which time the petition coordinators, a smaller group of members of Parliament, would convene and decide whether our petition should stay open or not. So July 11th, last Wednesday, a week ago, the petition committee met once again, and the result was the chair of the petition committee announced that the coordinators voted to keep our petition open. And we'll touch on that a little bit more in just a second, but it also stated that the committee is going to send a letter to the Spanish authorities to assess Morgan's situation. They're going to have to respond to that. And they've also asked the commission to, again, go back to the questions we raised in our petition, including the compliance with the directive, and provide a better answer than what they did. Part of this was interesting because Dr. Javier Almunia from Laurel Park actually flew to the hearing at European Parliament with us, and prior to coming, he wrote the committee asking to also have floor time to speak to the committee about our petition. And we were given notice by the chair of the committee, asked what our thoughts were, and we said it's a transparent, open public forum. It's up to the chair to do what she wants, and if he wants to have a time and they want to grant it to him, they're great to do that, but he has opportunities in our court case in the Netherlands. So the chair basically never granted Dr. Almunia permission to speak at the committee.
And he's from Laurel Parque.
He's from Laurel Parque. He's the director of the Laurel Parque Foundation and is basically overseeing everything that's happened to Morgan. And then a Spanish vice chair of the committee, who was very supportive of Laurel Parque, also asked during the hearing if Dr. Almunia could have the floor, and it was interesting that the chair just didn't even hear that question, totally ignored it. Dr. Almunia and his entourage, who had flown to Spain just for that hearing, were denied the opportunity because it really wasn't about them, and that's the other unique part about this. We are going after the European Commission for not following the law, not properly implementing the law, and as a consequence, we've seen what's happened with Morgan. So, to be continued. We're going to get a response from the Spanish authorities. We're going to have another opportunity for the European Commission or the European Parliament, and we're going to hopefully get the petition moving forward to make changes. It's a little late to stop Morgan from getting pregnant, but it's going to make some changes for any wildlife trade in the EU. It's going to add a lot of credibility to activists who are now policy and law advocates. And that's a big point for us. So, Ingrid?
Now that I'm a little more composed, I'd also just like to mention, and don't blush, Matt, but Matt had never seen wild orca before. He'd never seen an orca before. He's never seen Morgan. And so he saw orca the other day from Limekiln, so that was pretty cool. The other thing that's really notable is that Matt has literally spent thousands of hours on this. He's published some remarkable white paper reports. If any of you want to delve more into this, they're all listed on the Free Morgan Foundation website, and Matt has done all of this for free. questions because we know that the timetable's pretty tight here. So, there's one question here.
I was wondering, Matt, on the thing that you put up there where they were arguing for her to be exempted, it said at the end of that sentence where it was talking about how they were going to be able to use and abuse her, it said in a non-detrimental way.
Right.
Is that defined? And it's for whom?
No. I mean, when you read the words, it seems pretty clear and apparent that it's very limited. And these exemptions, our interpretation, are really supposed to be for a short period of time. It's not like one research project and then you get free use from then to do whatever you want, or even 2 research projects, or a year or 2 years. Literally, it should be they have an exact project in place, a medical need to do medical experimentation or a specific research project, and once that is accomplished, then they should return her to the wild, or in her case, we hope we can still get her out into a sanctuary. But again, the gatekeepers of the commission and the way they're interpreting these laws are really to favor the traders, the holders, the owners, the industry. Even though when you read the argument and the regulations, it's very clear that they do also have an obligation to the animals to protect them, and that's where we sort of made this little twist of the argument that's a little different, because it's there and they're just not doing it the way it's supposed to. We're not making up the wording, and as you saw when they cited this effectiveness report, it's not something new, but they're ignoring it because no one's actually challenged and followed an individual animal like Morgan all the way through these steps. And as Ingrid mentioned, the white paper, if you can't sleep at night, it's a great read. It'll knock you out. But it literally takes Morgan's case, and that's what's unusual about this. We can point to the one instance where this totally has failed her. I don't know if that quite answered your question, but...
So we've got time for one more question. Yeah.
This is sort of a follow-up. So there really isn't any precedent of any other exemptions that have been issued with other cetaceans, other animals that you can point to? Or...
Yeah. So the question was, have there been other cases like this? Yes, there are. But trying to get the information is extremely difficult. Where you saw the plethora of countries that we're operating under, and when we went to the Dutch, we said, we need some information. It took them over a year to do their Official Information Act filing and get back to us. And then they said, and by the way, this isn't our problem because she's in Spain. It's got nothing to do with us. So then we went to the Spanish. Same deal, took about a year to get the documents, 1 page, we might add, which was the certificate, which we already had. And then they said, and by the way, this isn't our problem because the Dutch sent her here and it's their problem. So, and we have this in writing. And so our next step in the to be continued is that we have also asked, you remember there were 3 asks. One of them is to go to the European Court of Justice, because we are sick and tired of dealing with these bloody governments. We're sick and tired of it. We want to go and get a ruling on this and stop them running around and hiding behind each other. They're all playing cover my ass, and we're sick of it. So, thank you.